Be ready 5 seconds.
Both the central as well as the state government had no intent of collecting additional goods and services tax on the higher price, as they had sacrificed their revenue in favor of the buyer. By compelling the buyers to pay the additional goods and services tax on a higher price, the supplier has not only defeated the intent of the governments but has also acted against the interest of the consumer, and therefore, the goods and services tax collected by him on the additional realization has rightly been included in the profiteered amount. In some cases, the petitioners have pointed out that the timelines as provided in the rules, 2017 have not been followed. They further contended that as a result, the proceedings are vitiated. However, it is important to note that the rules, 2017 do not provide any consequences in case the time limits provided thereunder lapse. As held earlier, the anti-profiteering provisions in the Act, 2017 and the rules, 2017 are in the nature of a beneficial legislation as they promote consumer welfare. The courts have consistently held that beneficial legislation must receive liberal construction that favors the consumer and promotes the intent and objective of the Act. That being the scenario, it cannot be said that the proceedings as a whole abate on lapse of time limit of furnishing of report by DGAP. The Supreme Court in P.T. Rajan versus T.P.M. Sahir and others, 2003, 8 SCC 498, has held that, it is well settled principle of law that where a statutory functionary is asked to perform a statutory duty within the time prescribed therefor, the same would be directory and not mandatory. And that, a provision in a statute which is procedural in nature and although employs the word shall, may not be held to be mandatory if thereby no prejudice is caused. Consequently, the time limit provided for furnishing of report is directory in nature and not mandatory. Section 171 of the Act, 2017 is widely worded and does not limit the scope of examination to only goods and services in respect of which a complaint is received. The scope of powers of the DGAP is provided for in Rule 129 of the Rules, 2017. From a reading of the said rule, especially the expression any supply of goods or services, used in sub-rule (2) of Rule 129, it is apparent that the scope of the powers is very wide. Stop.